Get ready for this. The bright lights of the Senate Judiciary Committee hearing room blazed down on Supreme Court Justice Brett Kavanaugh as he shifted uncomfortably in his seat. What had been scheduled as a regular check-in hearing was about to turn into the most dramatic moment in recent Supreme Court history. Just moments earlier, brand-new Congresswoman Jasmine Crockett had walked into the room carrying a thin blue folder that her colleagues barely noticed. But Kavanaugh's eyes had locked onto it immediately, his usual calm judge composure visibly shaken. "Justice Kavanaugh, thank you for appearing before this committee today," Crockett began, her voice calm and measured despite the tension filling the room. The Texas representative, a former civil rights attorney with a reputation for super careful preparation, placed the blue folder on the desk in front of her. The C-SPAN camera caught Kavanaugh's eyes darting toward it repeatedly. What the millions watching at home didn't know yet was that inside that folder lay a secret Supreme Court memo that had never been meant for public eyes, a document outlining internal discussions about a controversial ruling that contradicted Kavanaugh's public statements during his confirmation hearings. The memo contained handwritten notes in Kavanaugh's own writing that would call into question his sworn testimony to Congress years earlier. "I'd like to begin by discussing judicial transparency," Crockett said, opening the folder with deliberate slowness. "Specifically, I'm interested in the gap between what justices tell Congress during confirmation and how they actually rule once on the bench." Kavanaugh reached for his water glass, his hand visibly trembling as he took a sip. The committee chair leaned forward, puzzled by the justice's unusual behavior. Within minutes, a single document from Crockett's folder would trigger a reaction that no Supreme Court justice had ever displayed on national television, leaving millions of viewers stunned and the highest court in the land facing unprecedented scrutiny. Congresswoman Jasmine Crockett had risen quickly through the political ranks after a distinguished career as a civil rights attorney in Texas. Known for her methodical legal mind and unflappable demeanor in heated situations, she had earned a coveted seat on the House Judiciary Committee as a freshman representative, position that perfectly leveraged her background in constitutional law. "Representative Crockett, you have 15 minutes for questioning," announced the committee chair, unaware of the bombshell about toe drop in his hearing room. Across from her sat Brett Kavanaugh, whose 2018 confirmation to the Supreme Court had been one of the most contentious in modern history. After weathering accusations about his past and questions about his judicial temperament, he had settled into his role as a reliable conservative vote on the court. Over the past 5 years, he had largely avoided the public spotlight, preferring the cloistered environment of the court to the harsh glare of public scrutiny. Justice Kavanaugh Crockett began. "During your confirmation hearings, you made several specific commitments about your judicial philosophy, particularly regarding precedent and settled law. Would you say your rulings have remained consistent with those statements?" Kavanaugh leaned toward the microphone with practiced confidence. "Congresswoman, I believe my judicial record speaks for itself. I approach each case with an open mind and fidelity to the Constitution and President Justice I pledged I would." Crockett nodded, her expression revealing nothing. "And would you say that your private deliberations with other justices reflect that same commitment?" A flicker of confusion crossed Kavanaugh's face. "All justices engage in confidential deliberations. That's a core part of the court's process." "Of course," Crockett replied, her tone neutral, "but I'm asking about consistency between your public statements and private positions. Behind the scenes, what viewers couldn't see was the extraordinary circumstances that had brought this moment to fruition. 3 weeks earlier, a whistleblower from within the Supreme Court clerk's office had approached Crockett's staff with information about internal court documents that suggested Justice Kavanaugh had taken positions in private deliberations that directly contradicted his sworn testimony to Congress. After verifying the authenticity of the material through multiple sources, Crockett had made the high-stakes decision to use her questioning time to confront Kavanaugh directly. Her legal background had taught her that the most effective cross-examination comes when the witness doesn't see it coming. The stakes could hardly be higher. If the document was authentic, it would suggest a Supreme Court justice had been less than truthful under oath. If Crockett's gambit failed, She would face intense criticism for ambushing a Supreme Court justice based on potentially stolen confidential documents. Justice Kavanaugh, she continued, I'm particularly interested in your statements regarding Roe v. Wade during your confirmation. You testified that you considered it settled law and an important precedent of the Supreme Court. Kavanaugh nodded firmly. That was my testimony. Yes. And yet, Crockett said, reaching for the blue folder. 2 years before the DOB's decision, you circulated an internal memo to the other conservative justices outlining a strategy for overturning Roe, referring to it as an opportunity to finally correct this constitutional error. The room fell silent. Kavanaugh's face froze in an expression that the cameras captured in excruciating detail, a look of genuine shock that a member of Congress somehow possessed an internal court document. The committee chair sat up straighter, suddenly alert to the unexpected turn the hearing had taken. The confrontation was now set. A freshman Congresswoman with a prosecutor's instincts facing a Supreme Court justice who suddenly realized he might have been caught in a significant contradiction. Millions watching live were about to witness armament unprecedented in the history of Supreme Court oversight. I'm not familiar with any such memo, Kavanaugh responded after a moment, his voice noticeably tighter than before. But the slight tremor in his hand as Hegan reached for his water betrayed his discomfort. Crockett nodded, as if his denial was expected. Perhaps this will refresh your recollection, Justice Kavanaugh. She held up a document, making sure the cameras could capture it clearly. This is a memorandum dated March 15, 2020, with your name at the bottom, circulated to Justices Thomas Alto Gorsuch and later to Justice Barrett after her confirmation. The committee room erupted in murmurs. The chairman banged his gavel for order. Representative Crockett, if you're referencing confidential Supreme Court documents, I need to understand the provenance of these materials. Mr. Chairman, I'm referencing documents legally provided to this committee by a whistleblower concerned about potential misrepresentations to Congress. Crockett replied smoothly, a legal background evident in her precise language. And I would remind my colleagues that Supreme Court deliberations are not classified or subject to executive privilege. She turned back to Kavanaugh, who had been hastily conferring with his legal counsel. Justice Kavanaugh, this memo specifically states, and I quote, while public messaging regarding President is strategically necessary, we have the opportunity with the current court composition to finally correct this constitutional error. Would you like to explain the apparent contradiction between this statement and your testimony to this committee? Kavanaugh's face flushed. Congresswoman, without seeing the full context of any document you're referencing, I can't possibly comment on selective quotations that may be taken out of context. I'm happy to provide context, Crockett responded, turning to the next page. The memo continues. My suggestion is that we wait for a case without the procedural complications of the Louisiana statute, which would allow us to more cleanly address the core holding of Roe rather than merely chipping away at its edges. Does that additional context help your recollection, Justice? The tension in the room was palpable. Republican members of the committee began to object loudly, while Democratic members leaned forward in their seats, equally surprised by the dramatic turn of events. Point of order. The chairman called out a Republican representative. This is an ambush using potentially stolen documents. Justice Kavanaugh deserves advanced notice of any such allegations. The chairman looked uncertain, caught between parliamentary procedure and the explosive moment unfolding before him. The chair recognizes the concern, but the witness is present and able to respond to the question. As the procedural debate continued, the cameras remained fixed on Kavanaugh, whose judicial composure was visibly crumbling. His counsel whispered urgently in his ear, but the justice's eyes remained locked on the document in Crockett's hand. Mr. Chairman, Crockett interjected, I have additional documentation that provides further context. Perhaps Justice Kavanaugh would like to review it before responding further. She held up another paper. This is an email from Justice Kavanaugh to Chief Justice Roberts, dated 1 week after the memo referencing the strategy outlined, and noting that it would be, quote, prudent to maintain public ambiguity about our intentions regarding Roe until the right case presents itself. The revelation drew audible gasps from the gallery. Kavanaugh's counsel frantically scribbled notes, sliding them toward the justice, who seemed increasingly isolated under the bright lights and unwavering cameras. Congresswoman Crockett, the chairman, intervened. While this committee certainly has oversight responsibilities, I'm concerned about the method by which these alleged documents were obtained. Mr. Chairman, Crockett replied without hesitation. The Supreme Court has repeatedly ruled that the public interest in exposing potential wrongdoing. The hearing had transformed from routine oversight to armament of genuine constitutional drama. His response would either defend his integrity or confirm the existence of a shadow strategy that contradicted his sworn testimony. I need to consult with counsel before responding further, Kavanaugh said. His voice strained. Ash turned to whisper urgently to his attorney. Crockett waited patiently, the document still visible in her hand. The C-SPAN camera zoomed in on the header of the memo, capturing enough detail that viewers at home could see the Supreme Court letterhead and Kavanaugh's name. After a tense 30 seconds of whispered consultation, Kavanaugh turned back to the microphone. Congresswoman, internal deliberations among justices are confidential for good reason. They allow for the free exchange of ideas and perspectives. I understand the importance of confidentiality, Justice Kavanaugh, Crockett replied evenly, but my question is about reconciling your public testimony with private actions. These aren't just academic deliberations. This memo outlines a specific strategy to publicly convey one position while privately pursuing another. She held up another document. And I have here 3 minutes from a private conference among the conservative justices dated September 2020, where you specifically advised, and I quote, "We should be careful not to telegraph our intentions on Rao until after the election and then you appointment." The reference to timing strategically waiting until after Justice Barrett's confirmation caused another stir in the hearing room. Several Democratic committee members were now frantically passing notes among themselves, clearly caught off guard by the revelations their colleague had kept closely held until this moment. Kavanaugh's face had drained of color. The measured judicial temperament that Supreme Court justices carefully cultivate was crumbling under the precision of Crockett's questioning and the weight of the documented evidence she continued to produce. Justice Kavanaugh, Crockett continued, her voice remaining professionally calm despite the escalating drama. Did you write in a private email to Justice Thomas that, and I quote, "Our public statements about respecting President have successfully provided the necessary cover for our colleagues facing tough confirmation fights?" The question hung in the air for a painfully long moment. The Republican side of the committee sat in stunned silence while several Democratic members couldn't contain audible reactions to the explosive allegation. When Kavanaugh finally spoke, his voice had lost its judicial authority. "I don't recall any such communication," he said weakly. Crockett nodded as if his denial was anticipated. "Then let me refresh your recollection." She held up a printed email with clear highlighting. "This is dated February 12, 2021, from your official Supreme Court email account. Would you like me to enter it into the official record?" The chairman, now visibly uncomfortable with how the hearing had developed, cleared his throat. "The committee will take a 10-minute recess to consider procedural questions. Before we recess, Mr. Chairman," Crockett interjected smoothly, "I'd like to enter one final document into the record. This is a handwritten note from Justice Kavanaugh to Justice Barrett, congratulating her on her confirmation and stating, in Justice Kavanaugh's own handwriting, now we have the votes to overturn Roe as we've discussed. The camera caught Kavanaugh's physical reaction in real time. A visible flinch followed by a panicked glance toward his counsel. It was the kind of unguarded moment that Supreme Court justices trained in maintaining impassive judicial demeanors almost never display publicly. That note is dated November 2020, just weeks after Justice Barrett's confirmation and a full year and a half before Justice Kavanaugh joined the majority opinion in Dobbs, claiming that the decision to overturn Roe was based solely on constitutional interpretation rather than any predetermined agenda. Crockett concluded as the chairman's gavel came down for the recess. The damage was done. Viewers across America had witnessed not just the revelation of the documents, but Kavanaugh's physical reaction to them, a reaction that communicated more than any verbal response could have. The justice's credibility was crumbling in real time on national television. When the committee reconvened 10 minutes later, Kavanaugh's demeanor had changed entirely. Gone was the confident jurist, replaced by a man clearly engaged in damage control. "Mr. Chairman, before we continue, I'd like to make a statement." Kavanaugh began, his voice noticeably more measured, suggesting the recess had been used for intensive preparation. Internal deliberations among justices often include exploration of various legal positions and strategies. These confidential discussions are part of how the court functions, and they don't necessarily reflect final positions or personal beliefs. Crockett nodded thoughtfully, then delivered her final question. "Justice Kavanaugh, are you saying that when you told this committee, under oath, that you considered Roe's settled law while simultaneously writing memos about how to overturn it, you were just exploring various legal positions?" The pointed question, framing the contradiction in its darkest terms, left Kavanaugh with no room to maneuver. The silence that followed, lasting several seconds as millions watched, was his most damning response. Within minutes of the hearing's conclusion, the Kavanaugh memos began trending nationwide, with clips of the confrontation spreading across every social media platform. News networks interrupted regular programming to analyze what many commentators immediately described as the most significant congressional oversight moment involving the Supreme Court in modern history. By nightfall, major newspapers had convened emergency editorial meetings to prepare special coverage. The Washington Post's headline captured the gravity: "Constitutional Crisis. Kavanaugh's documents reveal potential testimony contradictions." The New York Times followed with supreme contradiction: "Kavanaugh's private memos versus public testimony." Legal experts from across the political spectrum flooded cable news shows to debate the implications. Harvard law professor Lawrence Tribe called it a seismic moment for judicial accountability, while conservative legal scholar Jonathan Turley acknowledged that, if these documents are authenticated, they present serious questions about candor under oath. Court watchers noted the unprecedented nature of the revelation. "The Supreme Court has always operated with extraordinary confidentiality," explained CNN's Joan Biskupic. "What Congresswoman Crockett revealed today isn't just about Kavanaugh. It potentially pulls back the curtain on how judicial confirmations have been strategically approached by nominees wary of revealing their true intentions." The White House issued a carefully worded statement. "The President believes in the independence of the judiciary and the integrity of congressional oversight. These are serious allegations that deserve thorough investigation through proper channels." Supporters of Justice Kavanaugh rallied quickly, questioning the provenance of the documents and accusing Crockett of an ambush tactic. "These could be fabricated, taken out of context, or illegally obtained," argue judicial crisis networks, Carrie Severinoon, Fox News. "This looks like a politically motivated hit job." But the visual impact of Kavanaugh's reaction, his visible panic captured in high definition and replayed countless times, proved difficult to counter. Body language experts analyzed the footage, with one telling MSNBC, "What we witnessed was a textbook example of someone confronted with evidence they didn't expect to exist." The physical reactions cannot be easily dismissed. For Congresswoman Crockett, the aftermath brought both acclaim and intense scrutiny. Progressive groups hailed her as a hero for judicial accountability, while conservative organizations filed ethics complaints alleging improper handling of confidential court documents. Legal defense funds for both Crockett and the unnamed whistleblower raised millions within days. The institutional fallout extended far beyond a single hearing. Chief Justice John Roberts announced an internal investigation into the source of the leaked documents, while defending the court's deliberative process. Senate Judiciary Committee Chair Dickton called for hearings on standards of candor for judicial nominees, while several House members introduced a Judicial Transparency Act that would create new disclosure requirements for Supreme Court justices. Constitutional. Scholars debated the most serious question: what happens when evidence suggests a sitting Supreme Court justice may have been less than truthful during confirmation? The Constitution's good behavior standard for judicial tenure had rarely been tested, and never in such a high-profile manner. Legal blogs exploded with analysis of potential remedies. Some argued that only impeachment could address the situation, while others suggested that public pressure might force a resignation. Law school ethics classes hastily rewrote syllabi to include the Kavanaugh Memo's case as required reading. Perhaps most significantly, public opinion polling showed an immediate impact on the court's already declining reputation. A Gallup flash poll conducted 2 days after the hearing found public confidence in the Supreme Court had dropped to an all-time low of 18%, with 76% of Americans believing the court had become too political. 1 week after the hearing, in a move that shocked Washington, Justice Kavanaugh announced he would temporarily recuse himself from certain categories of cases pending the completion of inquiries into the document's authenticity. The limited recusal, unprecedented for a sitting justice, was widely interpreted as an attempt to relieve pressure without admitting wrongdoing. The long-term implications became the subject of intense speculation. Legal historians noted parallels to the court-packing controversy under FDR, when external pressure led to a dramatic shift in the court's jurisprudence. We may be witnessing another switch in time that saved 9, suggested Yale law professor Calamar, referencing the historic moment when the court changed course to avoid institutional reform. For everyday Americans, the episode crystallized growing concerns about institutions once considered above politics. As one viral tweet with over 1 million likes succinctly put it, "When judges have secret agendas, do we really have rule of law?" 2 months after the hearing, in a lengthy feature in The Atlantic, the unnamed whistleblower finally came forward, a former Supreme Court clerk who described being morally compelled to reveal the documents after witnessing the gap between public assurances and private plans. The article sparked renewed debate about the ethics of whistleblowing versus institutional confidentiality. The most lasting impact came not from any single policy change, but from the fundamental shift in how Americans viewed judicial confirmations. In subsequent nomination hearings, senators from both parties began demanding more specific commitments and expressing open skepticism about generalized assurances regarding President. As constitutional law professor Melissa Murray observed in a widely shared analysis, the Kavanaugh-Crockett confrontation has permanently altered the relationship between Congress and the court. The era of allowing nominees to avoid substantive positions through carefully crafted non-answers may have come to an end. For Jasmine Crockett, the freshman Congresswoman who had prepared meticulously for her moment, the aftermath brought both professional acclaim and personal cost. Death threats required enhanced security, while legal challenges regarding her handling of the documents consumed significant resources. Yet her unwavering response echoed her closing statement at the hearing itself. When fundamental rights hang in the balance, the American people deserve complete honesty from those entrusted with protecting our Constitution, especially those with lifetime appointments. The constitutional drama that began with a blue folder on a committee room desk had evolved into something far more significant: a national reckoning with judicial transparency and the boundaries between necessary confidentiality and essential accountability in a democracy.